Welcome to the Village at Augsburg and our third installment in our legal webinar series here. It's great for me to see see all of you joining us today. I know a lot of you have been here for previous webinars, so thank you for coming back. And if you are new and visiting us for the first time, I want to give you a very warm welcome and just tell you a little bit about Augsburg before we get started with today's webinar. The Village at Augsburg is a continuing care retirement community, and we are located in Baltimore County. We've actually been here almost 130 years. So we have a really long history of taking care of people. And we offer independent living, assisted living, short-term rehab, and also skilled nursing care. So this is a place where you can come and spend the rest of your life and be taken well care of and treated kindly and safely. So we appreciate you joining us today. As Adrian mentioned, you will have an opportunity to ask questions. Like all of our webinars, this one is being recorded. So if you have to jump off early or you miss something, Adrian will be posting this to our YouTube channel, and also we'll send you a link to the recording so that you can watch it again or share it with somebody that you think may benefit from learning the information today. And so if you are wondering, what happens if I don't have a will? You have come to the right place today. And I'm very grateful to have Alex Zarzecki joining us from the law firm of Frank & Share. And good afternoon and welcome, Alex.
Thank you, Sin. Thank you, Adrian, as well.
You're welcome. It's great to have you here. And I told Alex before we started that I'm going to be listening intently today because I don't know anything about probate, and it's going to be a learning opportunity for me. Please feel free to ask your questions as Alex presents. Absolutely. And before we get started, though, I would love to use that little raise hand and just get an idea of, in the audience, how many people do have a will prepared at this point in their life? If you can use that little raise hand function down there, and Adrian can maybe give us a count, a tally. It's always good to just kind of have an idea of the audience before we start.
It looks like about half.
Half?
There's about half that have it, yes.
Terrific. Okay, so we have half that have it and then half that don't, but this conversation today is for everybody. So we're all going to learn something. So Alex, please give us a little bit of introduction, and then you are welcome to share your screen and get us some education on probate.
Thanks. So like Suzanne said, my name is Alex Zarzecki. I'm an attorney at Frank & Share. We are currently located at the Mount Washington Mill. We recently moved there from Lutherville. And I have been practicing since 2012 and spent the majority of my career at the firm. And so what we do, we are an elder law firm. What exactly does that mean? It means a lot of things. It means that we specialize in estate planning for individuals who are elderly, and we also do generic estate planning as well. So we assist individuals with their wills, with their financial powers of attorney, with advanced medical directives, living wills, revocable living trusts, irrevocable trusts. We also do special needs planning, and then we also do a significant amount of Medicaid planning. So for individuals who want to do some asset protection planning and also qualify a family member for some long-term skilled nursing care. And we also do guardianships and a multitude of other things. But today's primarily going to focus on the estate planning portion and specifically the probate and intestacy issues that come along with that. Also want to add that I am a certified elder law attorney. It's an accreditation that is governed by the National Academy or National Elder Law Foundation, sorry. And it's something that you are required to take a test for and have been practicing in the field for 5 years. So it's something that I'm proud of and worked hard to obtain. And so hopefully today's presentation will share some of my knowledge and generate some interest and questions that you may have. So
Well, Alex, if I can jump in, you actually do have a question.
Oh, sure.
The question is, do you review CCRC contracts?
Yes, absolutely. That's something we certainly do and advise clients on. CCRC contracts are usually governed or have to be approved by the county in which the CCRC is domiciled. And I guess Suzanne could probably answer this a little bit more thoroughly. So they are already vetted, but the actual planning process and some of the issues that arise from that are something that we certainly can advise clients on and do advise clients.
Yeah, I always recommend when someone is thinking about moving to Augsburg, if they have put a deposit on an apartment, they always receive a copy of the contract in advance of their move. And I always tell them, it's a great idea to have an attorney review the document with you so that you understand and your family understands what you are obligating yourself to and what Augsburg is going to provide for you. So I'm a firm believer in having that done.
Appreciate that. So if there aren't any other questions, I am going to, how should I share my screen? Is my screen being shared? There we go. Okay. So hopefully, Adrian or Suzanne, can you confirm that the PowerPoint is visible to everyone?
Yes.
Okay, great. So here is the beginning of my presentation. I have the funniest little cartoon that I could locate for this type of area. There isn't much to work with. So hopefully it gives you a little bit of a laugh because discussing this type of area is not always the easiest thing for some individuals. So in order for us to have a discussion about probate and estate planning, it's necessary to understand some of the terminology that comes along with it. So probate is the legal process of transferring a decedent's assets. When someone passes away, they typically have probate and non-probate assets. The probate assets are the assets that are titled in the individual's or the decedent's name alone without a co-owner or a beneficiary designation. And the non-probate assets are typically those assets that do have either a co-owner or a beneficiary designation. And the thing that many people don't understand is that if an item has a co-owner or a beneficiary designation, that supersedes anything indicated or an instruction within a last will and testament. So it's something that it's possible that you may have an estate where you don't have anything to probate because everything has transferred directly to a co-owner or a designated beneficiary. So I've referenced a will. A last will and testament is a written document which describes how property is distributed at the decedent's death. A male is referred to as a testator, a female is referred to a testatrix. And I will get into the actual requirements of executing a will later on in the presentation. So next slide references a codicil, which is usually an addition or a qualification that is made to an existing will by the testator or testatrix to alter or add a provision to a previously existed or executed will. We actually don't do many codicils anymore, and that's probably due to technology. And I usually recommend just re-executing the entire document again to avoid the possibility of losing two separate documents. I think codicils were much more popular during the days when a typewriter was used instead of a computer, and it was easier to just type out the addition or the revision rather than retyping the entire will out again. So codicils definitely do exist, but we try to avoid them to create simplicity and just one single document for our clients. A will nominates somebody called a personal representative. The personal representative is, it's referred to in different terms in different states. Some states use executors, some states use administrators, some use conservator, but it's the fiduciary, the individual who is nominated to administer the decedent's estate and follow the terms of the will, and then ultimately make the distributions pursuant to the will. A legatee is a person who is nominated within the document who is receiving a portion of the probate estate. It can be either a specific bequest where you're either leaving a specific item to an individual or a charity or a corporation, or it can be for a residuary share of the estate. So a percentage of whatever is left over after the specific bequests are made and after all the debts and expenses are paid. Another term that was very important is intestate or intestacy, which is the process of administering an estate if an individual dies without a will. I was actually surprised by the number of individuals who said that they have wills, because it's probably lower than most people would expect. And a lot of people who you would think would have wills ultimately do not. I think from a celebrity perspective in the past few years, we've had Prince, and I think I'm blanking on her name. She just had a movie come out for her. Aretha Franklin. Both died without wills, which caused complications in their estates, which were probably bigger than the average estate due to the fortunes that they amassed during their lifetime. But their probate processes were complicated by the fact that they didn't have wills and didn't leave a clear indication as to who they wanted to receive from an estate. And in the case of intestacy, the individuals who are entitled to the share of the estate are referred to heirs. So I mentioned a legatee earlier on and an heir now. They aren't necessarily the same individuals, but for the most part, if you leave your estate to your immediate family members, they will cross over and be the same individuals. But that doesn't mean that you have to leave your assets to your heirs at law. And I will touch on that a little bit later as well. So in each county in Maryland, there is a register of wills. It is the office which is responsible for overseeing and administering the estates of decedents. So in order for a personal representative to act, they are required to get something called a letter of administration. Some states call it a letter of testamentary. It is the document that authorizes the executor or the personal representative to act on behalf of the estate. The nomination alone within a last will and testament does not authorize a personal representative to act on behalf of the estate in Maryland. You have to have the letters of administration issued by the Register of Wills in order to act. So in addition to the Register of Wills, there is also an orphans court in each county except for two in Maryland. Montgomery and Harford counties have their circuit courts act as the orphans court. But essentially the orphans court is the probate court that oversees the Register of Wills and settles any disputes that arise during the administration of an estate. So if someone wants to contest a will or file an exception to an accounting that is filed by a personal representative, you have to make a motion within the orphans court in order to have your motion and position heard with respect to the issue that you are raising. All right, moving on. I'm going to go back to intestacy, which I mentioned earlier, which is the process that applies when a person dies without an executed last will and testament. So the will is typically where you nominate an individual to serve as the personal representative for your estate. If you died intestate, you haven't executed the will, so you have not nominated a individual to serve as the personal representative for your estate. So who serves at that point? Maryland law indicates a order of priority as to who serves. And that's assuming that you actually pass away and are domiciled in Maryland at the time that you pass away. So I should have mentioned this earlier. Maryland probate only applies to individuals who are domiciled and considered to be Maryland residents at the time that you pass away. If you live in another state, and that's where you typically file your income taxes and where your residency is based, that is the state where your probate estate will be administered and the controlling law. So Maryland only can control individuals who have passed away and resided in the state of Maryland. And so going back to the nomination of a personal representative within an intestate estate, anybody can petition the court to serve as the personal representative, but in order to have the appointment occur without a court order, all of the individuals who may have a higher level of priority above you have to consent to your appointment. If that doesn't occur, then it is necessary for there to be something called judicial probate, in which a hearing is held before an orphan's court judge to appoint the personal representative to handle the administration of the estate. And the order of priority is relatively similar to the Maryland intestate distribution. And so it's typically your immediate family members, the surviving spouse, the children, grandchildren, and kind of goes down the flow chain. And I will go into that in the next few slides, which actually might be the next one. Yeah. So what happens when you don't execute a last will and testament? So Maryland law hypothesizes a few different scenarios, and here's kind of a quick rundown as to who would receive your estate if you don't sign a will. If you are only survived by a spouse, you don't have any surviving children, grandchildren, or any other lineal descendants, and your parents don't survive you, then the surviving spouse is entitled to the entire probate estate. If you are survived by a spouse and minor children, then the spouse receives 1/2 of the probate estate and the children receive the other half. And that's usually where, when clients come to me, that makes their eyes kind of go big, because depending on what your family makeup is, most estate plans for most of our generic and clients is that if we have a married couple, that everything goes to the surviving spouse, and then upon the death of the surviving spouse, everything goes to the children. But in Maryland intestacy, the children are entitled to 1/2 of the probate estate upon the first spouse's death, which is not typical of estate plans that I prepare for clients, especially if there are minor children. If there are minor children who survive, that would then also require some form of guardianship, because a minor child, anyone under the age of 18, is not in Maryland allowed to manage assets. So the court actually oversees the administration or the guardianship of the minor child until they turn 18. And I've run into that issue a few times and actually serve as the guardian of one. And it's actually quite restrictive. It's what they call a restrictive guardianship account. Distributions to be made for the minor child are not allowed unless you have specific authorization from the court. So anytime you want to make a distribution or buy something for the minor child, you have to petition the court for authority to do so. And that can be really cumbersome and time consuming, because you have to file a motion and have it heard before the court, and they have to make a decision. Sometimes they may require a hearing just to make a determination as to whether or not it's appropriate for the minor child. Going back to the intestacy, if a spouse and adult children survive, so there are no minor children, then the spouse is entitled to the first $40,000 of the probate estate. And then the remainder after the $40,000 first bequest to the surviving spouse is split between the surviving spouse and the adult children. If a decedent is not married, but they do have surviving children, then the children receive the entire probate estate. But what happens if you aren't married, or if you are married, but you don't have any surviving children, but you do have a surviving parent? Bullet number 5 looks at that scenario, and it's similar to the adult children number 3, where the surviving spouse would receive the first $40,000, but then 1/2 would go to the surviving spouse and 1/2 to the parents if the surviving spouse has been married to the decedent for a period of less than 5 years. So not something that I typically put into my estate plans, but something that the Maryland legislature considered and put into code when they were putting this together. So what happens if neither a spouse nor children survive? Where does the estate get distributed? At that point, you look to the surviving parents if there are any. If there are not, then you look to see if there are any siblings, and if there are no siblings, you look down and see if there are any nieces or nephews, and so on. If there aren't any surviving parents or lineal descendants of those parents alive, then you look up to the grandparents, and if there aren't anybody there, you look to the great-grandparents. So my next slide will show that a little bit more in effect. And then what happens if you can't find anybody, no surviving relatives? At that point, your probate estate escheats to the state of Maryland, which means that your estate gets distributed to either the Maryland Department of Health or the Board of Education. So going back to the previous point about determining who receives your estate if there are not any surviving parents or lineal descendants. So if you look at this family tree that is actually provided by the Maryland Register of Wills, you can see that they have all these different branches. Maryland goes up to as high as number 3, the great-grandparent, and then falls down on the branches below. That's as far as they will go in looking for a possible heir. I don't know about most of you, but I don't know who my second cousin once removed is, and I'm pretty sure that I don't want someone that I do not know receiving my probate estate. So it's just more of a sign that especially if you don't have a large immediate family, that an estate plan is extremely important, because otherwise your assets may go to someone who you either don't know or just really don't want your assets to go to. So the division of shares in Maryland is predominantly governed by this Latin term called per stirpes, where the property is divided into as many shares as there are at the first generation of children of the decedent. And so what do I mean by that? I've got a few slides which show exactly how that is handled here in Maryland. So in the hypothetical that I am proposing, I have a husband and wife. They have 3 children, A, B, and C. A has 2 children, U and V. B has 1 child, W, and C has 3 children, X, Y, and Z. And so under Maryland law, what happens when the husband and wife pass away and they are survived by all of their children and all of their grandchildren? In this scenario, A, B, and C would each split the 1/3 of the estate, but the grandchildren would get nothing. And that's probably respective of what most estate plans that I prepare are within a last will and testament, is that grandchildren typically don't get anything unless their parent has predeceased them, unless there's some specific request that a grandchild or grandparent wants to give them. But that's pretty common and straightforward, and what you would expect the fall of a per stirpes distribution to B. But what happens if husband and wife have passed away, but A has predeceased them? What is the distribution of the estate at that point? In this scenario, U and V would share the 1/3 that was previously supposed to go to A. So they would each get 1/6. B would still get 1/3, and C would still get 1/3, but the children of B and C would still not be entitled to anything because B and C are still alive. And I think you can probably tell where I'm going to go with my next hypo. I'm also going to have B predeceased. So in addition to A, B has predeceased the husband and wife. How is the estate distributed? In this scenario, A's 1/3 goes to U and V as it did in the previous one, and B's entire 1/3 goes to B's child W. C still gets C's 1/3, but X, Y, and Z get nothing. So the slight change here is that U and V, while they are each grandchildren of husband and wife, don't get the same amount as W because B only had one child. U and V are required to share their parents' 1/3, while W receives B's entire 1/3. And my final one, all three children, A, B, and C, have predeceased. How does the estate get distributed? Under a per stirpes distribution, U and V still get their 1/6, which is the 1/3 that they are splitting of A. B's 1/3 goes to W again, but X, Y, and Z have to share the 1/3 of C. So they only get 1/9 each. And so while U, V, W, X, Y, and Z are all within the same class, their distributed amounts are all slightly different. And some clients don't want that, but this is what the Maryland legislature has put forward. So in one of my previous slides that described per stirpes, there was a reference to per capita. And so, which is why it's important for you to have an estate plan. Per stirpes is the Maryland standard. It's the default. So that if you don't make any reference, that's what will flow. But what if someone wanted, instead of the per stirpes where U, V, W, X, Y, and Z all get different shares, that all of the grandchildren would receive the same amount? That's where per capita comes into play. And so under a per capita with representation clause in your will, in this scenario, U, V, W, X, Y, and Z would all share a 1/6 interest and all equally share within the estate rather than having these different portions. So my point in just sharing this was to just show that having an estate plan is important, especially if you aren't satisfied with how an estate would be distributed under the Maryland default rules. So who qualifies as an heir of an estate? A spouse inherits from a decedent if they are married at the time of their death. So regardless of whether they were separated or in the process of getting a divorce, until the court issues a divorce decree ordering that the marriage is dissolved, you are considered to be a spouse. And in Maryland, the only person that a decedent is unable to disinherit is a surviving spouse. So that is actually really important. And if you do not want your surviving spouse to receive a share of your estate or to receive a smaller share of your estate, it's important to have a will in place to go into that. And I'm going to have an additional slide because Maryland law recently changed that goes into this a little bit more and explains exactly how you're unable to disinherit a surviving spouse. Maryland does not have common law marriage, but Maryland will recognize a common law marriage that is obtained in another state as long as it requires with those guidelines. And obviously, same-sex marriage is recognized federally at this point. So that deals with spouses. Regarding children, children born in wedlock are considered the children of their natural parents. So what that means is if an outside party were to get involved, a child born within a marriage is considered to be a child of the marriage, unless there is something else that is brought to clarify who the legal parent is. Half-blood siblings are treated the same under the intestate statutes. So what I mean by that is that if you have children from different marriages or different relationships, they are considered to be equal standing as a child of the deceased individual. Children born out of wedlock are only considered to be the child of their mother unless the father takes some action, some assertive action to recognize the child of his own. And so what I mean by that is either they are listed on the birth certificate of the child, or they have adopted the individual, or they make some form of child support payment that essentially acknowledges that the child is theirs. And adoptive children are treated as the full blood descendants of adopting parents, which also means that they are no longer considered to be an heir of their biological parents. So I mentioned this earlier, Maryland's new elective share statute. It went into effect on October 1, 2020, so a little less than a year ago. And it's something that all estate planning and elder law attorneys are still learning and dealing with. It's a pretty drastic change in the law. And the easiest way for me to explain this is that under the old law, it was actually very easy to disinherit and not provide for a surviving spouse. And essentially you could do that by having your estate pass outside of probate and not be subject to an election by the surviving spouse. So if you had everything placed in a revocable trust, where you had co-owners and beneficiary designations, and none of those listed your surviving spouse, and there was nothing within your probate estate, then essentially, unless you made some specific provision for the surviving spouse, they may not be entitled to anything. And that's why Maryland made a pretty drastic change in their law. Maryland now follows something that is generally recognized nationally as the augmented estate, which takes into account both the decedent's probate estate and their non-probate estate. So that includes something such as a revocable trust, which the decedent was a grantor or settler of during their lifetime, anything that the decedent had a qualifying power of disposition over, which essentially means that they had a beneficiary designation over. So that could be something like a life insurance policy or a bank account or a brokerage account, which has a beneficiary designation. It also includes the qualifying joint interest. So it just means that any account that the decedent had a co-owner with, and then any gifts, lifetime transfers made by the decedent. So if you decided to transfer your assets prior to passing away, it's possible that that is something that would fall back into your augmented estate and be part of an election that the surviving spouse is able to make. And so what type of scenario would a surviving spouse want to make an election against a deceased spouse's estate? Typically, that would be in a scenario where they are not receiving assets that they consider to be sufficient for the purposes of receiving from both the probate and non-probate estate. So if you look at the bottom right-hand corner of this slide, the elective share equals the estate subject to the election. So if a person has children, it's divided by 3. If there are no living descendants or issue, then it's divided by 2. So let's use my numbers as an example. Let's just use a straight $1 million. If a person dies with an estate worth $1 million, but they have surviving children, then the surviving spouse is entitled to an election of $333,333.33. So in that scenario, a spouse would make an election if they were not provided that amount by either the probate estate or, sorry, by the combination, the combined value of both probate and non-probate assets going to them. So if they received less than the $333,000 that they're entitled to, that's when they may consider to make an election against the deceased spouse's estate. I'm not going to spend too much more time on this because it's kind of a niche and narrow issue, but it's something that's new and something that people should be aware of because it drastically changes Maryland's law with respect to surviving spouses and their share of the estate.
Hey, Alex, I do have
Yes.
3 questions that have come up. One
Great.
is, where does the stepchildren fit if not adopted in present marriage?
So stepchildren are not considered to be heirs at law. If you want to provide for a stepchild, you have to either do that within a last will and testament, or you have to do it with some other non-probate mechanisms, such as a co-ownership or beneficiary designation. If you don't have a will and you don't provide for them in that will, then they are not entitled to anything.
Okay, thank you. And the second question is, when do you secure a letter of administrator or appoint the administrator?
So that occurs after the individual has passed away and after a death certificate has been issued. So it's usually a matter within a few weeks to within a couple of months of the individual passing away. The Department of Vital Records has actually been a little bit inconsistent recently, well, I guess in the past 2 years with the pandemic, in issuing death certificates. It used to be, before this all went through, it used to be a matter of days, and now it usually fluctuates between a few weeks to a month before a death certificate is issued. So in order to have letters of administration, you have to have a person pass away and a death certificate issued to apply.
Okay, and there were actually 4 questions, I'm sorry. The third question is, can the POA be the same person you appoint as the administrator?
Yes, the power of attorney can be the same individual as the personal representative, but those are 2 different documents. The power of attorney is the person nominated within a financial power of attorney. A personal representative is appointed within a last will and testament. So they're not necessarily the same person a lot of the times that they are, but don't think that a financial power of attorney nominates or appoints a personal representative for your estate. The financial power of attorney actually dies with the individual and is no longer legally effective upon the principle of the power of attorney's death.
Okay, and the last question right now is it necessary to register your will with the Register of Wills office?
Okay, that's actually a good question. And it's not exactly, it's a little bit complicated, slightly. So what we typically do with our clients, when they come in to execute a will with us, we usually suggest that their original be placed in safekeeping at the Register of Wills. And the reason we do that is there are a few different reasons. One, it's cheap. The register charges a $5 fee to have the will placed in their safekeeping. And it's a great program because it's cheap and they don't lose the will. Wills, depending on their complexity, can be a few pages or they can be 20 pages if there's trust within them. But it's a relatively easy document to lose. So we always recommend that clients have their wills, once executed, filed with the Register of Wills for safekeeping. Having said that, the will, while they are alive, is only accessible to the testator or testatrix. It is not a public record at that point, and it's not a public record until you ultimately pass away. So while you're alive, you have the ability to revoke or amend your will. So that applies while an individual is alive. Upon death, there is actually a requirement within the Maryland Code that anybody in possession of an original last will and testament who has knowledge that that individual passed away, they have a duty to file it with the probate court. So that kind of goes along with our line of why we ultimately suggest to our clients why the will gets filed with the Register of Wills, is because that's where it ultimately has to go. And we just bypass that process and take care of it immediately upon execution. I hope that answers that question. And actually,
It did. It did. And I believe that there was another question that just popped
Sure.
up about the cost to file.
Yep. The counties charge $5 for that. It's not an attorney's fee. It's a fee that the register charges to place a will within the safekeeping program. And it's something that you can do yourself as well. You don't necessarily have to go through an attorney if you decide to draft a will by yourself, which I really don't advise. But it's something that anybody can do. You just take it to the Register of Wills. They charge you a $5 fee and they give you a receipt showing that it's been deposited there. So
Great, thank you.
That question actually leads us pretty well into our next slide, which concerns the will. So what are the requirements for a last will and testament in Maryland? 3 of them. It has to be in writing, signed by the testator or testatrix, and witnessed by 2 or more individuals. Doesn't necessarily have to be notarized, although we typically have all of our legal documents notarized. And that's more of the reason we do so is for it to be recognized if an individual moves to a state outside of Maryland that has certain requirements. But yeah, it just needs to be in writing, signed, and witnessed by 2 individuals, preferably individuals who are not specifically mentioned in the will or related to you. So if you come to my office, members of my firm will be the individuals who act as the witnesses. And so a person who executes a will also has to have something called testamentary capacity. It's not within the code. It's actually something that's established by common law and case law. And the question is whether the individual has sufficient mental capacity is determined by a consideration of their external acts and appearances. And so what that means is that the individual executing the will has to have an understanding of what they're doing. They have to understand that they are executing a last will and testament. They have to understand what their assets are and who they want to give them to. And they also have to have an understanding of the objects of their bounty. I just like saying that. It's something you never otherwise say, which means that you have to have an understanding as to who your heirs at law would be if you don't execute a last will and testament. So as long as you have those 3 things, you have testamentary capacity. It's a pretty low level. It's probably one of the lowest levels of cognitive capacity that is required. It's less than entering into a contract. It really just requires periods of lucidity. And as long as someone can meet these, then then usually we are comfortable having an individual execute a will. And if we ever have a question about whether or not someone has that cognitive capacity to execute a will, obviously we would meet with the client in the drafting process and in the intake process of meeting with them and understanding exactly what they want and making sure that they understand. But if there's any question or if we have any expectation that someone may contest the will, then additionally, what we also recommend clients to do is meet with their primary care physician to have a physician's certificate executed, just further acknowledging that the individual has sufficient capacity to execute legal documents. So a lot of times clients come to us and they want to revoke old wills. It's actually not a complicated process at all. Executing a new will automatically revokes a previous will and codicils. And then you can also revoke a will through the fun ways of either destroying it, burning it, or tearing it up. But there are a few other possibilities that revoke a will or the parts of a will. So if an individual has executed a will, but subsequently they get married and have a child, all previous wills that they executed are no longer considered to be effective. So essentially that individual becomes intestate because it did not take into consideration their marriage or their children. And I kind of appreciate that because I think if that occurs, that's a pretty significant change in the estate plan of, or it's presumed to be a pretty significant change in the estate plan of the individual. Something else that revokes part of a will is the divorce or annulment of a marriage. So if an individual executes a will and it references their spouse, but they subsequently get divorced, then all provisions relating to that divorced spouse are considered to be void and no longer effective. So that's obviously very beneficial, but it's important to note that it doesn't apply to assets that pass outside of probate. So let's say, for example, that you get married, ultimately get divorced, but that during your marriage, you bought a life insurance policy or you had a retirement account. And one or both of those accounts had the spouse designated as the primary beneficiary. The subsequent divorce does not automatically revoke that beneficiary designation. It's something that you, as the individual who got divorced, need to update. And so it's just another consideration in your estate plan process and something that you should be aware of. Like I mentioned earlier, a will only controls those assets that are in a decedent's name without a co-owner or a beneficiary designation. Things passing outside of probate pass directly to the designated beneficiary or co-owner. So we've talked a lot about kind of intestacy, estate planning. Let's talk about the probate process. And check, we're a little short on time, so I'm going to make this rather generic and kind of go through the essentials. I've mentioned numerous times the difference between probate and non-probate. I'm not going to go through that again, but just for our purposes, the Register of Wills primarily only has jurisdiction over the probate assets. So if most of your assets pass outside of probate, the Register of Wills does not have jurisdiction over those assets. The personal representative. Like I mentioned earlier, you have to petition the court to serve, and you don't legally become the personal representative until the court issues the letters of administration. A personal representative is a fiduciary, and they are held to the highest standard of care that you can be held to. And if they breach that fiduciary standard of care, it's possible that that individual could become personally liable to the beneficiaries of the estate. So that's something like misappropriating funds, stealing funds from the estate, or applying them to something that they shouldn't do. And if a personal representative fails in their role for whatever reason or breaches their fiduciary duty, they can be removed by the court and someone else can be appointed in his or her place. And then PR is also entitled to compensation for their services. There is a Maryland statute that deals with the calculation of that commission. So in Maryland, we have two different types of estates. We have a regular estate and we have a small estate. I'm going to talk about a regular estate first. And that's anytime the probate assets exceed $50,000 or $100,000 if the surviving spouse is the sole heir or legatee. And the value of the estate is calculated as the fair market value of the assets at the time of death of the decedent, less any debts that are secured by the property at the time of death. So let's say, for example, you have a house and it's worth $300,000, but the secured mortgage against the property is $285,000. So essentially you have $15,000 in equity for the estate. That wouldn't necessarily qualify as a regular estate because you really only have $15,000 in equity. While the asset may be worth $300,000, it's not worth that much to the estate because you have a secured debt. And so the items that are required to open a regular estate, you have to have the original last will and testament. So that kind of goes more into line of why I suggest that the original will be filed with the Register of Wills so that it doesn't get lost. If you are unable to locate the original will, you do have the option to file a petition to admit a copy of a last will and testament. But a court will most likely only accept a copy if all of the individuals who are listed in the will and all of the heirs at law consent to the probate of the will. And so typically, for the most part, the heirs at law are usually going to be the individuals listed within a will. But if they're not, the heirs at law, if the heirs at law for some reason are not within a last will and testament, they are not likely to consent to the admission of a copy of a will, because that essentially would remove them from receiving any portion of the probate estate. So just a further reason why it's important to have a will and to have the original placed in safekeeping so that it doesn't get lost. And then you can see a few of the other things that are filed. We file a death certificate, the petition, a notice of appointment. When someone passes away, the estate is required to notify creditors and unknown heirs that an estate has been opened. This is done through a notification in a paper. We typically use small local papers in each county. In Baltimore County, it's the Daily Record, which is the attorney's paper, where a lot of legal notices get placed. And it runs for 3 consecutive weeks, and it acts as a notice to creditors and unknown heirs and anybody who has an interest in the estate that they essentially have 6 months to file a claim against an estate. If they fail to do so, then they are forever barred for initiating a claim against the estate. Another thing that is required is bond. Another reason to have a will is that most wills excuse the bond of a personal representative. If bond is not excused, then you are required to, the executor is required to be bonded for the value of the assets in the probate estate. And so if you have an estate worth $2 million, then the personal representative, unless the bond is excused by the will, required to be bonded up to that $2 million value. And so that can be an expensive fee within the estate. It's not going to be $2 million, but it's going to be several $1,000s in order to have an insurance bond held for the executor. If bond is excused, the only expense for the estate is typically a nominal bond, which usually only costs the estate $100. So it could be having a will and excusing bond could mean the difference between a few $1,000s in expenses for the bond. And then the last thing on this page that is referenced is a list of interested persons. So one thing that the executor files with the Register of Wills is this list of interested persons. And that includes everybody who is listed within the will and all of the heirs at law. And so when an estate is opened, the Register of Wills actually issues notice to all of the interested persons that an estate has been opened, and basically gives them information to contact the Register of Wills or the personal representative if that person has any questions. So within 3 months of opening a regular estate, the personal representative is required to file an inventory and information report. The inventory reports all the probate assets at their fair market value, and the information report details any assets which the decedent owned, which passed outside of probate, but to individuals who are subject to inheritance tax. And I think I have a slide later on that kind of explains what inheritance tax is, and I'll get to that later on. And then after that deadline has passed and after those are filed, the next deadline is typically within 9 months of the letters of administration being issued. The personal representative is required to file an administrative account. The administrative account is a detailed penny by penny accounting of the activity in the estate from the date of death through the date of filing the accounting. And depending on the assets of the estate, it can be something that is extremely complicated and time-consuming to prepare. Primarily, it falls in estates where a decedent owned a brokerage account, and the brokerage account is generating a lot of dividends, interest, and other income that has to be reported on the accounting. The reason the accountings are filed are just to provide the beneficiaries of an estate with an accounting so that they can see what they're entitled to receive from the estate, and also question what the executor has been doing during the administration period. There is a probate fee that is associated with the estate, and it's based off the size of the estate. I'm not going to get into that too much. Claims against the estate, debts. So what happens if you have debts? Maryland law indicates that in order for a claim or a debt to be secured against an estate, the creditor is required to file a claim with the Register of Wills within 6 months of the decedent's date of death, or within 2 months of receiving a copy of the notice of appointment from the personal representative. So I very rarely advise clients to pay any debts other than those that are necessary, like a mortgage or a car loan, during the administration process, until one, they've actually secured, the creditor secured the claim, and two, you've actually confirmed that you have sufficient assets in the estate to pay all of the debts. If you're unsure about there being sufficient funds or liquidity in the estate, then you don't want to have the estate pay it, because they may not be entitled to the exact amount that they are due. Any claims not filed within that 6-month period are barred, and the estate is not required to pay. So it's quite interesting and quite limiting in that effect. So small states. Yep.
Alex, I'm sorry, can I ask you a quick question? We do have someone that would like to know if insurance policies are a part of your assets.
So typically insurance policies have a designated beneficiary and would pass outside of probate. But there are circumstances where you either may not have designated beneficiary and it just gets defaulted to being payable to the estate, or you have designated your estate as the beneficiary. So those are typically the only two scenarios where a life insurance policy would be payable to an estate, a probate estate, that is.
Thank you.
So let's quickly wrap up with small estates. Small estates are much more streamlined and less complicated than a regular estate. It's when the value of the probate assets are less than $50,000. You still file many of the same similar items, but you don't file a formal accounting with the Register of Wills. Instead, you kind of report assets as they come in, and then distribute them pursuant to either the will or Maryland intestate. It's actually funny that small estates can sometimes be a little bit more complicated than regular estates because you don't have to do that accounting. And so if you do have beneficiaries, they usually want to see why they're getting a specific amount, and you end up doing an informal accounting that doesn't necessarily get filed with the court, but just explains exactly what everybody is getting. I'm not going to go over modified administration. It's a part of a regular estate, but it allows for a streamlined accounting, so you don't have to do that penny by penny accounting. It's only available in situations where estates don't have inheritance tax and all of the beneficiaries of the estate consent to the modified administration. So the typical probate process, you can see that here. I'm not going to go too much more into it, but it's pretty clear, and this is very, very generic. Each estate is different and has its own complications based off of the assets and the composition of the estate. And a lot of times, the main complicating factor can either be outstanding or due taxes or creditors of the estate. Undue influence in a will. I'm not going to go into this too much, but it's just another reason why it's beneficial to go to an attorney when drafting your estate planning documents. A lot of these things can be addressed within meeting with an attorney and going through the proper procedures. So if a client comes to me and they meet with me individually, and I am certain, and we have a physician's certificate indicating that they have capacity, it's extremely hard to challenge a will or make a claim that undue influence existed. So that's why we usually suggest that clients come to us for drafting their estate planning documents. This just, an attorney is also entitled to a fee for assisting with the administration of the estate. And this is what I wanted to touch on at the very end. Inheritance tax. Maryland is one of the few states, I think we're one of 4, that still applies inheritance tax to estates. So here's a list of individuals who are not subject to inheritance tax in Maryland. Grandparents, parents, spouses, children, grandchildren, and other lineal descendants, spouses of a lineal descendant, so stepchildren or in-laws, siblings, and nonprofit organizations. So if you have an estate and you have assets that pass to an individual outside these class of individuals, you're going to have inheritance tax. And inheritance tax is typically a flat 10% fee. It can add up pretty quickly because if you have $1 million estate, that's $100,000 in inheritance tax if those assets all pass to someone who is subject to inheritance tax. And Maryland also still has estate tax. So if you have a gross estate that exceeds $5 million, you may possibly be subject to Maryland estate tax. It only applies to a small portion of the population, but it still exists. For federal purposes, the estate tax exemption is $11.7 million. So it applies to even far fewer. So unless you have assets exceeding $5 million, estate taxes are not something that you have to currently consider. Having said that, there has been talk nationally about reducing the federal estate tax exemption because it is so high. It went up to 11.7. I believe it was either 2017 or 2018. I can't remember the exact time. And it was a drastic increase from where it previously was, which was at 5 million, a little bit north of $5 million. And you can see there's information here regarding estate tax. It doesn't apply to many people, but it's something that we need to be aware of because Maryland's estate tax exemption has changed drastically over the past decade. When I started practicing back in 2012, it was only $1 million. So it actually applied to a lot of our clients who had, especially married couples who had home and retirement accounts. It's very easy to exceed $1 million. And at that point, you were required to do some more elevated tax planning within your last will and testament. Unless you have more than $5 million, or if a couple has more than $10 million, it's not necessary to do this complicated estate tax planning. And you can usually get by with a relatively simple last will and testament if that's what you want to do. And I think that's all I have in my slide. I apologize for rushing through at the end, but I'm happy to take any questions that anyone may have now. And I'll also, I think my phone number was at the beginning of the slide. Feel free to reach out to me that way or through email if you have any additional questions. But I appreciate the time that you guys all provided and attending, and I hope that I was able to provide some information or at least reconfirm some of the ideas that you had regarding the probate and estate planning process.
Yeah, thank you very much, Alex. I actually found the presentation I could follow along, like it wasn't too legalese for me. And you know, it really was informative and very clearly presented. So thank you for sharing.
Appreciate it.
And thank you for spending time with us today. To everyone who attended, thank you very much. We will send you Alex's contact information when we send, Adrian will actually be sending the email out with the link to today's recording. So we'll make sure that Alex's contact information is in there, and feel free to reach out to him, you know, directly with your specific questions, or if you want to set up an appointment to meet with him. We've had 3 really great presentations in a row, and I think they've all been very concise, but they have helped people understand this process more. So thank you again, Alex. I would love to have you come to Augsburg in person one day and maybe do this live.
Absolutely. It's much more interactive and fun when you're live rather than speaking at a computer screen.
We have a lot of people who are still not on Zoom. They're not comfortable, doing webinars. They want that in-person experience. So we're hoping that by, next spring, everybody will be vaccinated and Delta will be gone and Mu will be gone, or whatever the new one is that's coming, and we'll get a little more normal. So we'd love to have you come to Augsburg.
Absolutely. That's the hope.
Great. Well, thank you, everybody, for joining us. We will see you actually in 2 weeks. It's our final presentation, and it's Medicare 101. If you haven't registered for that, you can do so on our website. We'll also be sending out an iContact for that. It's on Facebook, so you can sign up through that link. And hope you all have a great rest of the week. It's going to be a beautiful weekend, kind of an early tease of what's coming in the fall. So I hope you enjoy that, and we will see you again soon. Take care, everybody, and thank you again.
Thank you, everyone.